Trump Legal Cases Daily Digest, December 28, 2023. A surprise from Maine. This week's focus is on Trump's anticipated appeal to the Supreme Court following last week's ruling by the Colorado Supreme Court, barring him from the state's 2024 GOP presidential primary ballot. The ruling is based on a post-Civil War constitutional amendment preventing insurrectionists from holding office. Trump has expressed his intention to appeal, and the filing occurred today through the Republican Party. It's important to note that Trump's status on the ballot, as the Republican frontrunner, doesn't impact his ongoing 4 criminal trials. The court schedules are anticipated to become more active in the new year, with oral arguments scheduled for January 9 in the D.C. Circuit Federal Appeals Court to decide whether Trump's federal election obstruction case should be dismissed due to presidential immunity. In a stunning decision today, the Maine Secretary of State excluded Trump from the ballot. Stay tuned for updates on these legal developments. Maine excludes Trump from ballot amidst Supreme Court Section 3 debate. In a groundbreaking move, Maine's Democratic Secretary of State, Shenna Bellows, has taken the bold step of removing former President Donald Trump from the state's presidential primary ballot under the Constitution's Section 3 of the 14th Amendment. This unilateral decision comes amidst a national debate over whether the provision, prohibiting those who engaged in insurrection from holding office, applies to Trump's role in the January 6, 2021, attack on the U.S. Capitol. Bellows' ruling follows a similar decision by the Colorado Supreme Court and sets the stage for a potential showdown at the U.S. Supreme Court, emphasizing the need for clarity on the state's authority to exclude candidates under Section 3. Legal experts highlight the significance of Bellows' decision, emphasizing the necessity for the U.S. Supreme Court to address the merits of Section 3 to guide states' actions uniformly. Critics argue that these decisions will persist until the highest court provides decisive guidance. Trump's campaign, responding to the Maine ruling, called it a sham decision resembling third world dictatorships, while House Republican leader Billy Bob Fockingham criticized it as a partisan move. Despite facing pushback, Bellows defended her decision, asserting it was based solely on the evidence presented and not influenced by political affiliations. With Trump's legal battles intensifying, this decision adds another layer of complexity to the ongoing debate over the interpretation and application of Section 3, potentially shaping the landscape of the 2024 presidential race. Colorado Republicans challenge Trump's exclusion, seek swift Supreme Court intervention. The Colorado Republican Party has officially petitioned the U.S. Supreme Court to reverse the Colorado Supreme Court's groundbreaking ruling earlier this month that disqualified Donald Trump from the state's presidential primary ballot. The state GOP, represented by the American Center for Law and Justice, asserts 3 key arguments: that the 14th Amendment does not cover the presidency, the insurrection clause requires congressional enforcement, and states cannot autonomously make determinations. The party contends that Trump's removal infringes upon its First Amendment association rights. This legal maneuver intensifies the battle over Trump's eligibility and highlights the divergent interpretations of the 14th Amendment, setting the stage for a pivotal Supreme Court intervention. The legal clash, stemming from Section 3 of the 14th Amendment, which bars those who engaged in insurrection from holding office, enters a critical phase as the U.S. Supreme Court is officially called upon to address the matter. The Colorado Supreme Court's unique decision marked a significant departure, with other state Supreme Courts opting to defer the issue. Trump's legal team maintains his innocence, arguing the amendment doesn't apply to the presidency. As the primary ballot certification deadline looms on January 5, the urgency for an expedited Supreme Court decision intensifies. Both the state GOP and challengers, supported by Citizens for Responsibility and Ethics in Washington, have urged the court to expedite the case, emphasizing the need to reduce voter confusion ahead of the 2024 primary elections. The state Supreme Court stated that an appeal would automatically maintain its hold, while election officials there will continue to be required to include President Trump's name on the 2024 presidential primary ballot, until the receipt of any order or mandate from the Supreme Court. Second Circuit rejects Trump's bid to delay E.J. Carroll defamation trial. Former President Donald Trump's legal challenges continue as the Second Circuit rejects his attempt to delay the civil defamation trial brought by E. Jean Carroll. Scheduled to begin on January 16, this trial marks the second civil case against Trump related to Carroll's allegations of sexual assault in 1996. Despite facing multiple criminal trials, this defamation case takes precedence as the first legal battle Trump will encounter in the 2024 election year. U.S. District Judge Lewis Kaplan had previously ruled Trump liable for defamation, and the upcoming trial will focus on determining the extent of damages owed to Carroll. The Second Circuit's decision to proceed as scheduled underscores the complexity of Trump's legal entanglements, with the court dismissing Trump's motions for stays, maintaining the trial's imminent commencement. Trump's legal team, led by attorney Michael Medallo, sought a delay in the trial, arguing for the necessity of addressing Trump's claims of presidential immunity before proceeding. He wrote, "The requested stays are necessary and appropriate to give President Trump an opportunity to fully litigate his entitlement to present an immunity defense in the underlying proceedings, including pursuing the appeal in the Supreme Court if necessary." They continued, forcing President Trump to stand trial absent a final determination as to whether his presidential immunity defense is viable would be the quintessential form of prejudice and would deprive the immunity of its intended effect. However, the Second Circuit refused to halt proceedings, asserting that Trump had waived his immunity defense by not immediately invoking it when Carroll first filed the lawsuit. Carroll's legal team responded, highlighting Trump's gamesmanship at every stage of this case. They argued that, moreover, given that the waivability of this particular immunity defense has never previously come up, or at least, has never been disputed, there is no reason to think this court's decision imperils the effective functioning of the tripartite government. And considering the press of far weightier matters at the Supreme Court, including several cases involving the same defendant, there is not a reasonable probability that the Supreme Court will grant review in this case. The circuit's decision echoes a similar strategy employed by Trump in his criminal case in D.C. federal court, where he faces charges related to attempting to subvert the 2020 election. With Trump standing as the frontrunner in the 2024 Republican presidential primary, these legal battles carry significant implications for his political future and the ongoing legal scrutiny across multiple jurisdictions. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.